Attorneys are held to high ethical standards under the state bars under which they are licensed. And it has to be this way because we as attorneys hold people's lives and or their livelihoods essentially in the palm of our hands. If we don't uphold the ethics that are required of us by the state's bar, then real consequences come to our clients. So consequences have to come to us when we violate those ethical standards. According to Jacksonville Today, a former elected defense attorney, public defender, has been disbarred for violating his ethical duties. Let's have a look. The article reads, former public defender Matt Sherk disbarred. The Florida Supreme Court has permanently disbarred former public defender Matt Sherk from practicing law in the state. The action follows a court order in 2021 that suspended Sherk for 6 months after he pleaded guilty to ethics violations committed when he was the public defender in the 4th Judicial Circuit in Duval, Clay, and Nassau counties. A court order in August 2022 suspended him for a year, and a new order filed Wednesday says Sherk is disbarred permanently for practicing law during that suspension. So you've been suspended once, you got suspended again, and then you practiced law during the suspension and got disbarred. The court found he handled court duties for 4 different immigration clients in 2023. 4 clients that he was practicing law for while he was suspended from the practice of law. The order demands that Sherk pay $1,250 in court costs. Sherk could not be reached for comment Thursday. First elected public defender in 2009, Sherk was re-elected in 2013, then lost his bid for a 3rd term in 2016. Sherk was initially investigated after the Florida Auditor General issued a scathing report that documented how he misused staff and funds for personal gain and may have illegally deleted records, something he had been accused of in the past as well. A grand jury also recommended Sherk be removed from office, but then Governor Rick Scott declined, and Sherk was unwilling to step down. Sherk was initially fined $6,000 after admitting to a number of ethics violations. Those included allegations that he improperly hired women to work in the public defender's office, then directed that they be fired for the private benefit of himself and to save his marriage, according to the referee's report. The Tributary, a Jacksonville Today news partner, reported that claims included hiring one woman after seeing a photo of her working as a ring girl at a boxing match. So he sees this person acting as a ring girl, and without looking at a resume or knowing any potential qualifications that she may or may not have, she's hired. Another woman was a waitress, and a third was the girlfriend of the then president of the local police union, according to investigative reports. At work, Sherk repeatedly sent 2 of them sexual messages and took another on out-of-town work trips. Investigations also revealed that Sherk invited the women to join him in his office shower. He also illegally drank with 2 of the women in his office, then fired them after his wife found the messages. Court filings also stated that Sherk disclosed or used information not available to the general public for personal gain or to benefit anyone else. The violation occurred when Sherk revealed information about a former child client to a television documentary crew, violating attorney-client privilege in the high-profile case of then 12-year-old Christian Fernandez, who was accused of murder. The order this week stated that Sherk was held in contempt for representing clients during his suspension. He filed a notice to represent 4 different immigration clients with the U.S. Citizenship and Immigration Service, the filing states. When one of those clients asked Sherk whether he was going to represent him at his hearing, Sherk advised the client that he was suspended from the practice of law, but that respondent would contact the immigration court and determine what the client needed to do. Later, Sherk filed motions with the court to continue hearings scheduled for 3 clients rather than advising his clients of his suspension from the practice of law and taking the reasonably necessary steps to protect their interests due to his inability to continue representing them in their immigration cases. In August, Sherk also filed an emergency motion on behalf of a client in a removal proceeding with the immigration court in Orlando. In the end, the Florida bar asked the state Supreme Court to order Sherk to show why he should not be held in contempt and disbarred immediately. Sherk responded to the filing in mid-November, saying that he had been in full compliance with the court's order of suspension. Not if you were representing clients, Mr. Sherk. The preparation of applications and forms with USCIS does not require bar membership or any special licensing. Any person can prepare applications and forms on behalf of applicants, Sherk stated. Additionally, respondent could not find other counsel to file anything on his behalf. Sherk concluded that he was not practicing law during his suspension or attempting to litigate any matter or give any legal advice. He said he was simply notifying immigration court officials that he was still suspended from practice and could not appear on behalf of the clients in question. The Florida Supreme Court disbarred him 12 days later. Good for you, Florida Supreme Court. Good for you. He should have been disbarred a long time ago if he was doing all of the things that this article says he did and that you suspended him for in the past. You probably should have disbarred him then, but good for you for disbarring him now. It's people like this who put attorneys in a bad light, put the justice system in a bad light, and make us all out to be bad people. Media does it well enough. Let's just let them do it without giving them fuel to add to the fire. Let's do that. Tell me what you think in the comments below. For now, I'm Nathan Saunders, and this is The Legal Good.